Padilla.
Thank you, Mr. Chair. I know our time is limited and the hour is long, but wanted to at minimum get in one question directed at Professor Hassan. Professor, Justice Alito, like many of my Republican colleagues he has held himself out to be a champion of textualist judicial philosophy. The basic premise of the philosophy is that judges should start with the words of the statute as they would be understood at the time they were written, and if they are clear, go no further. Any additional analysis would step beyond the role of a judge and is considered, quote, inappropriate judicial activism. But in writing the Brnovich majority opinion, Justice Alito abandoned textualism altogether to reach a conclusion that is entirely divorced from the actual text of the Voting Rights Act. His analysis laid bare that for the conservative majority of the Supreme Court, textualism only applies where it is convenient to reaching the desired case outcome. Professor, can you explain how Justice Alito's opinion in Brnovich effectively ignores the text of Section 202 of the Voting Rights Act?
Thank you, Senator. So the first thing I would say is that Justice Kagan's opinion in the dissent is, I think, a much more faithful textualist interpretation of what the words of the act actually say in the context in which they were written. Justice Alito has not been as strong of a textualist consistently as some of the other conservative justices. If you think of Justices Gorsuch and Thomas especially, they signed on to this opinion. This was a 6-3 opinion. The 6 conservative justices, including the 3 justices appointed by President Trump, have been strong supporters of textualism. Justice Kavanaugh wrote an article in the Harvard Law Review embracing textualism, and yet this opinion abandons textualism. They came up with these guideposts that have absolutely no connection to the text of the statute or to even to precedent, which is something that textualists will often look to, or to just the earlier versions of Section 2. And again, this part of the act was rewritten in 1982 because the Supreme Court got it wrong in 1980 in the City of Mobile versus Bolden case, when the court said that Section 2 did not cover discriminatory results. Congress clearly put it back in, and any honest textualist would understand that this was an effects test that would ask, as Justice Kagan explains in her dissent, the first question is, are minority voters treated worse? And if you can say that they're treated worse in any voting law, that's what this should go for, should be targeted at. And what Justice Alito did was smoke and mirrors to just make it easier for states to defeat Section 2 claims in this area.
Okay. Now I have one quick question for all 5 of the witnesses. It's a simple yes/no question. And I'd ask that you each respect my question with a simple yes/no response. The preface to the question is this. When I was in high school government class, I remember our teacher teaching us that our democracy works best when as many eligible people participate. Did my high school teacher get it right? Yes or no, Professor Hassan?
Yes.
Ms. Nelson?
Yes.
Mr. Garza?
Yes.
Mr.
Yes.
Cuccinelli?
Yes, and with confidence and transparency.
Mr. Noble?
Yes.
Thank you. And I mean, it seems like a simple concept, but I ask it for the record because I've heard far too often, not just from several of my Republican colleagues this year, but for many years from Republican leaders, including elections officials across the country, this supposed philosophy of all we want to do is make it easier to vote, but harder to cheat. The data suggests we've gotten the harder to cheat down pretty good. Every study, every investigation has not only documented but quantified voter fraud in America as exceedingly rare. What my colleagues seem to have forgotten about is the first part of their mantra, the easier to vote piece. And so I know this is not a hearing on the For the People Act, but as the former Secretary of State of California, having not just championed but successfully implemented a lot of the measures called for in the For the People Act, policies like automatic voter registration, same-day voter registration, no excuse vote by mail, the ability of voters to choose a voting location in their county most convenient to them if that is their choice, same-day registration, and more. We know that it's not just good for the voter in terms of improving ballot access. It actually, these policies taken together also help improve election security and protect the integrity of our election. So yes, election integrity is a concern and a responsibility. But if we all agreed with my high school government teacher and all of you said yes, government also has a role and a responsibility in facilitating that participation of all eligible voters, and that is what should be driving the actions of Congress and state houses today. Thank you, Mr. Chair.
Thanks, Senator Padilla. Senator Lee, I interrupted you, and if the ranking member has no objection, I'll let you continue.